Hello and welcome to the launch of the School Inclusions Project. There may be one or two people who are still joining, but I think we've got about 80 people now, and so they can join as and when, and I hope that that will be shortly. We're very pleased to welcome you all to the launch of what we hope will be an important and effective project challenging the incidence of school exclusions, seeking to ensure access to justice for those who are subject to temporary and permanent exclusions, ever increasing numbers of young people, to identify and challenge and change the systemic discrimination that underpins much of school exclusions, and provide young people and their parents with legal advice and representation so that their rights and interests can be better protected in what is one of the most challenging areas of practice in law currently, and where in many ways the state is systemically failing many young people. The project, as you will have seen from the publicity, is a joint partnership between Garden Court Chambers, of which I'm one of the joint heads of Garden Court Chambers and a public law practitioner, along with the Law Centres Network, which, as I'm sure you're familiar with, covers the whole body of law centres across the country, as well as organisations with long-standing expertise and commitment to representing young people at risk of exclusion, the Just for Kids law and the Communities Empowerment Network, both of them having very long-standing connections with grassroots organisations and individuals who are challenging and have been challenging what is increasingly seen to be one of the most scandalous aspects of systemic and structural discrimination in the United Kingdom. So what I was intending we would do is for the panelists, of which we've got a number, to give you to introduce themselves and give you a little bit of an outline of who they are. I will then do a brief introduction to be followed by three elements of this webinar today. One, looking at the issues that we're seeking to address through this project. Two, then moving on to looking at what provision there currently is, both in terms of representation, what work is covered by legal aid, and we're very fortunate to have Phil Story from a firm of solicitors in the Midlands, Bailey Wright & Co., who's going to give us an insight into his experience, as well as looking at campaigning and policy work, partly to set up the big question, what needs to be done? And I hope to some extent answering that question in the third part of the webinar with the work that the Schools Inclusion Project hopes to do. And we'll set out what the model is, what are its aims, and how, I hope, having been inspired by what you've heard, how you might join it and contribute to its work. So as I said, my name is Stephanie Harrison. I'm one of the heads of Chambers at Garden Court. I haven't got any direct experience prior to getting involved in this project in education law. I'm learning fast, which is what I know many other people in Chambers have also done, because there's 60 members of Garden Court who have committed themselves to provide and to participate in providing representation. What I would bring is my experience in public law to this area. So I think if we could go around, maybe Phil, you could talk next.
Yes, I'm a solicitor at Bailey Wright & Co, and I specialise in education. I've been at the firm since 2002, and we have contracts for education law, discrimination and public law. We've got a particular interest in exclusions involving discrimination, and also when there's been unmet special educational needs, and also in terminations of managed moves. We're obviously concerned over the years that the rights have been eroded. with the introduction of head teachers on panels, and then the independent appeal panels being relegated to independent review panels. So that's been my involvement. So I've been involved in exclusions for a number of years, and it's increasingly difficult these days, and so I want to be part of the project.
Great. Jonathan?
My name is Jonathan Akinetwe. I'm part of the school exclusion campaign at Just for Kids Law. Having gone through exclusions myself, we've been part of the team since April. And what we do, we work to raise awareness around the long-term impacts on kids that get excluded, and also just trying to work on that campaign and policy just to bring about change within this area. I'm happy to be part of this discussion today.
Michaela?
Hi everyone, my name is Michaela. I'm a youth engagement and campaigns organiser at Just for Kids Law. I have the absolute privilege of working with young people who have lived experience of school exclusions and support them to campaign for wider educational reform. And I work with Jonathan and Rose, who are here on the panel today.
Florence?
Hi, my name's Florence Cole, and I'm one of the education and community care solicitors at Just for Kids Law. I've been at Just for Kids Law now for 7 years, but I've been doing education law since 2010 when I was at Streetwise Community Law Centre. And the majority of my cases are representation at governing bodies and independent review panels. And I think over the years, I've seen it sort of like get progressively worse. So continue to support young people and parents, and bearing in mind that the young person is our client. And so they are at the heart of every case that we do. And I also work with Michaela as well. Thank you.
Ruba?
Hi everyone, my name is Ruba Halejo. I'm the Young Persons Advisor at Harrow Law Centre. Most of my work with clients is concerning education law, school exclusion, special educational needs. But years ago, actually, while I was on the bar course, I was a volunteer advocate with Communities Empowerment Network. So I represented a few people through Communities Empowerment Network. And at the moment, I have been working with them through Harrow Law Centre through this school exclusion project, and some cases have been referred. Very happy to be with you today.
Thank you. Ollie?
Hi, I'm Ollie. I'm a barrister at Garden Court. I specialise in public law and education law. And I too was a volunteer at Communities Empowerment Network when I was a bar school student.
Rose?
Hi, my name is Rose Akinshavire, and I'm a campaigner. And I'm here part of this panel because I want to be able to be part of the change for young people to be able to get better services to the government and through any other ways to charities like Just for Kids Law as well.
Thank you. Professor John? I think you're on mute.
Okay, sorry about that. Gus John, I chair the trustees of Communities Empowerment Network. I'm one of the founders of the organization. I founded it in 1999 with Jerry German, who had been the principal education officer at the CRE until a short while before we started. I came to it from an experience of activism, really, having been involved in starting the Black Parents Movement and campaigning against the whole scandal of sending loads of Black kids to ESN schools. So I've been involved in schooling issues and the denial of Black children's education rights since the early 1970s, middle 1960s, really. I'm particularly pleased that this SIP is being fronted, if you like, by Garden Court, with whom I have worked since its inception at 2 Garden Court. I grew up with Ian MacDonald, Nick Blake, Tim Cook, and all of those wonderful people. And Ian has actually represented many parents for us in the Black Parents Movement long before CEN. I'm happy to welcome Ruba and Ollie. It's good to see you again. I'm glad that you're graduates of CEN. And we look forward to working with everybody in this partnership.
Maxine?
Hello, I'm Maxine. I'm a volunteer advocate at CEN. The others have said a lot about what we do, but most of our work is in regards to exclusions, permanent, fixed term, but we're also seeing an increasing number of SEN cases come through. That said, we do deal with a variety of cases, and our main aim is to empower parents, and we're seeing a lot more of parent strength coming through at the conclusion of cases. And yeah, we're including parents a lot and empowering them to set up their own networks. So yeah, that's us, and we're happy to be a part of this. Thank you.
Stefan?
Stefan's having some trouble with signal at the minute, so he might be dipping in and out. Sorry about that.
Michael?
Hi everyone, my name is Michael Etienne. I'm a public law and human rights barrister at Garden Court Chambers, with a particular focus on state actions and cases that touch on issues of systemic discrimination. Of most relevance to tonight's discussion, I have been representing pupils and their parents in school exclusion hearings, typically in front of the independent review panels, also in some cases in front of the first year tribunal since about 2016, and have had the great privilege of doing quite a lot of that work with the fantastic team at Just for Kids.
Thank you. So if Stefan can introduce himself when he comes to speak, and just so that you're clear, is that we are recording this webinar, and it will be broadcast subsequently on YouTube. Stefan, for that reason, doesn't want to have his face shown, which is of course acceptable. Obviously, for everybody else, I hope that it's acceptable to you that it is going to be recorded. And if not, I'm afraid that's already set in stone, and that's what we're planning to do, so that the message can get out to as many people as possible about the project and its aims. As you can see, one of the primary aims of the partnership and of the project is to bring together across the board lawyers, advisors, academics, advocates, campaigners, people who have had the direct experience of exclusion, whether that be parents or young people, like we have Stefan, Jonathan and Rose coming to speak to us today to give us first-hand account of what this process is like and how it can be intimidating and daunting given the life-changing consequences that can occur. So we hope that it will be one of the strengths of the partnership, that it does have a broad base. And we think that that's vital, not least because, as we have all indicated, one of the primary issues that we wish to tackle and address and seek to change through this project is the fact that it is absolutely apparent from the government's own statistics that it's structural disadvantage and discrimination that is at the heart of the implementation of this draconian policy of exclusion from school. The statistics are shocking. They show first and foremost that it's socioeconomic groups, disadvantaged groups, who are 6 times more likely to face exclusion than others, that it's young people with disability and special educational needs, often going unidentified, even through a process like exclusion, with young people with special educational needs 5 times more likely to be permanently excluded. And then there are significant racial disparity. Black and Caribbean children are 2.5 times more likely to be excluded than their white counterparts. Irish travellers, similarly, 2.5 times more likely to be excluded, and Gypsy and Roma children 4 times more likely to be excluded. We know from experience, and people will talk about that exclusion is not just about loss of educational opportunity. It results in social exclusion. It often leads to situations where young people find themselves outcast and liable to be involved in criminal activity. The shocking statistic is that 58% of all young people in prison have been excluded from school. And we're going to hear in particular from Ruba about that element of the connection between exclusion from education and criminalization. We also know from our work in immigration that it's often children who have been excluded from school, frequently because their special educational needs haven't been identified, who then find themselves not just having convictions, but then next step is deportation if they don't have a secure immigration status. And that can even include young people who are born in the United Kingdom, who have lived here for many years, and whose whole family are in this country. So the systemic structural discrimination results in action of a draconian kind that is taken by the state. So we can't identify, and we tried to do so in thinking about what our response would be to the Black Lives Matters campaign. What can we do? What can we put our energy in to respond to the challenge that was set for us in terms of addressing structural discrimination? And we think this is at the heart and a very important element of challenging institutional discrimination. That's the context in which we have pursued this project. It is also about access to justice. We'll hear that there is clearly an enormous need. Before the lockdown, 22 young people were excluded from school every day. The need is unmet, and whilst there are exceptional and excellent provision, like from Just for Kids Law, some solicitors like Bailey Wright and co, law centres like Harrow Law Centre, there is a dearth of legal representation and access to advice, especially at an early stage. And in many respects, this is a legal black hole when it comes to what is happening before governing bodies and in the independent review panel. It's very much part of our strategy that we would hope to establish the right to public funding taken away by LAPSPO, and to establish the ability on a sustainable basis for access to properly funded legal services, in order to shine a light and to bring some structure and improved due process guarantees that currently don't really operate within this area, and of course ensure that those subject to this process, whether it is the child directly who currently has no right to pursue the claim in their own right, to be able to do so, and the parents, in a context where often they are overwhelmed, disempowered by the process that their child and young person is subject to. So we have set ourselves some important aims, and we hope to achieve that through a number of steps, both in terms of providing representation to individuals, to pursuing strategic litigation to establish the right to public funding, that Article 6 is engaged in a exclusion decision, and to improve due process and natural justice guarantees within the process itself. We also recognise that within that, it's critically important to identify where it can be identified on an individual basis, as well as on a systemic basis, where race and other forms of discrimination play a part in the decision making. We're also very keen to engage on a general level and to pursue policy change. There have been a number of initiatives recognising that there's a need for wholesale change with regards to the current arrangements, the need to remove the first tier of review from the governing body so that it goes to an independent reviewer, and thereafter to bring the independent review panel into the ordinary provision tribunal system, so that you do have access to a court or a tribunal that has the full powers, including powers to reinstate those who have been wrongly excluded. And we wish to engage on a policy level to bring those changes to the system, but perhaps more importantly, to engage on a generic level in seeking to reverse the trend of ever increasing use of exclusion, to overall ensure that it is only ever used as a matter of last resort, rather than as it seems to be at the moment as a first resort for any pupil that presents substantial challenge and difficulty for the school, and would want to aim not for school exclusion but school inclusion as the touchstone for what is good practice. And so with all that in mind, we will explain as we go through the webinar how the project works and how you can contribute to it. But starting off then, we want to just give you the context for the process and how the different forms of discrimination impact upon the process. And I'm going to ask Michael to talk about that.
Thanks very much, Stephanie. So we thought it'd be useful for the benefit of anyone in the audience who's less familiar with the process, just to give a very brief overview of how the exclusion process works, as Stephanie was indicating. And the first stage is the decision of the head teacher to permanently exclude a pupil. And we're focusing for the present purposes on permanent exclusion, although much of what we'll say applies equally to fixed term exclusion, particularly in terms of the systemic issues. And the power of exclusion at the first stage is exclusively the head teacher. So they have a central role in this entire process, and that can cause problems in certain cases where, in fact, the head teacher themselves are in some way implicated in the events that lead to a permanent exclusion. So, for example, if they're a witness to the events that they then come to rely on in order to justify excluding somebody, and I've seen that in at least one or two of my cases. After the head teacher has made their decision, there's an automatic obligation on the governing body of the school to then review the head teacher's decision. And whereas the head teacher decides whether or not the relevant test for permanent exclusion is met, the question for the governing body is slightly different. The question for them is whether or not the pupil ought to be reinstated. In effect, in all the circumstances, the role of the governing body, generally speaking, as many of you will know, is to ensure that the decisions taken in the name of a school or an academy are lawful and in accordance with all the legal obligations that apply to schools. One of the problems, though, is that head teachers, senior management team typically have very close relationships with governing bodies, and there is a mutual understanding that governing bodies were slow to do anything which might be seen to undermine the authority of the head teacher. And one of the most common responses that you'll get to challenging any kind of decision making around exclusions is that, well, I had to do this in order to send some kind of message about maintaining discipline in the school. I've had a case very, very recently where a school told told an independent review panel that if they were to do anything other than uphold the permanent exclusion, they would effectively bring the entire house down. And that is often the level of rhetoric that we are faced with as advocates for excluded children and their parents. From there, you typically can appeal, and as Stephanie touched on a moment ago, it's a right of appeal that actually is only held by the parent. So the excluded pupil can't apply to the independent review panel to review the governing body's decision, which can cause some problems in circumstances where there's a potential for a conflict of interest, potentially between the parent and the pupil for whatever reason. Again, the independent review panel system is not, in my view, entirely independent. Part of the reason for that is you have a panel of 3 people. One would be either a serving or a former head teacher of a different school. Another will be a former or serving governor of a school. Both of those may be from schools within the same local authority area as the school that you are challenging the exclusion from. And so you can know without it necessarily being said that the likelihood is that the professionals in the room will have crossed paths with each other. Yes, there are obligations on panel members to make declarations of conflict of interest and so on, but there's lots more tacit understanding that exists between professionals in those circumstances. And then you have a lay chair, which is someone who is lay in the sense that they're not an education professional. What's really important to know, and something which we'll probably go to talk on in a bit more detail later, is that none of the actual panel members are required to be lawyers. They should have training in exclusion law, but the quality of that training is variable, to say the least. They have access to a legal clerk who does have to be trained. Again, the quality of that training is often poor. I've had a number of arguments with legal clerks about the most basic elements of the law in this area, which is set out in some, generally speaking, helpful statutory guidance, which is really, really concerning. And the other problem with independent review panels is that they're asked to apply the principles of judicial review. Irrationality, illegality, failure to take account of relevant considerations, bias, so on and so on. Anybody who knows anything about the law knows that those are not always easy concepts to explain to other lawyers, never mind people who aren't lawyers. And I think it's just particularly instructive in setting up the conversation to refer to one of but still the only recent authority on school exclusion legal framework in the case of CR. It's a case that I cite often. But this is what Mr. Justice Collins said in that case, having referenced the principles of judicial review. He said, "I'm bound to say that it's difficult to see that it's entirely satisfactory for what is a lay body to be required to apply judicial review principles in a decision that they have to make, which is whether or not the decision to reinstate is lawful. However, that is what Parliament has required, and that is what, so far as possible, is to be applied." And I just think it's really worth reflecting on that, because effectively what that tells you is that the system itself is structured in a way that is going to be dysfunctional to a minimal degree, if only because people who are not qualified lawyers are asked to apply complex legal principles, and they have to put up with people like me turning up, setting out the law often in quite a lot of detail in an attempt to guide them, but often what you get is resistance to that. So that's just a very basic indication of why the system doesn't work. And then we get to potential fourth means of challenges to the first tier tribunal for special educational needs and disability. So that will only be in cases where disability is an issue in the exclusion. And again, the FTT, generally speaking, is better than independent review panels because at least you have qualified lawyers. But again, the quality of decision-making can be variable. And I have lost cases that I thought were classic examples of disability discrimination. So there are issues there as well. And that, of course, contributes to the systemic issues because the structure of the system is defective from the beginning. And so then when you're trying to argue potentially complex legal principles of what is and isn't discrimination, it's incredibly difficult. And you get the same resistance to raising issues about race, particularly, as you do in any other walk of life. It's the instinctive defensive reaction. We're not racist. There is no racism in this school. We're an inclusive school. Look at our lovely, shiny equality and diversity policy. It is just over 50 years this year since Bernard Cord wrote his seminal book about how the West Indian child is made educationally subnormal in British schools. There is very little evidence that many of the issues that were raised in that book have changed significantly. Much more recently, in 2020, the Runnymede Trust produced a report on racism in secondary schools, unsurprisingly indicating that it is systemic. And they touched on 4 really key areas, which is teacher recruitment, the use of police officers in schools, the curriculum and school policies. all areas of school life in which issues of racial discrimination, disability discrimination, and so on are serious and in some cases rife. And what is most frustrating is that the statutory guidance that the government produces tells every decision maker with responsibility for exclusions that they must have proper regard to the disproportionate rates of exclusion of all the pupil groups that you heard Stephanie mention. And I venture to suggest you could name all of those groups without anybody telling you, because it is the same repetition of systemic discrimination that we see in the criminal justice system, in the courts, in prisons, in mental health institutions. And that is why there is now overwhelming evidence that demonstrates that we have a exclusion to prison pipeline that is as well established here as it is anywhere else. And there has to come a point at which this is dismantled, and hopefully this project will make some contribution to setting in train a process that is worthy of the children that at the moment is fundamentally letting down.
Thank you, Michael. Gus, I don't know whether it would be an appropriate moment for you to give us some of your insight about, obviously you've been working in this field for a very long time, but what you could tell us about obviously the roots of it, but how you see it, the key factors operating at the moment.
Yes, thank you for that. And thank you, Michael. That's very helpful. There are a number of factors, really. You mentioned, Stephanie, the denial of rights to parents in one respect, the abolition of independent review panels, and the institution of these appeal panels to review panels. Before we even get to that point, I believe that there is a general culture of expectation within schools about Black children and their conduct, to the extent that even when they are victims of discrimination, schools tend to prefer the accounts of the children doing the discrimination as against those who are actually discriminated against. I have been involved in teacher training for God knows how long, at least since the 1970s. I was a director of education in the borough of Hackney between 1989 and 1977. And the one thing that I can say is this, and Michael has alluded to it, the same kinds of prejudices and the status that Black people have within the society and other walks of life feed into schools and the managers' perceptions of Black, not just Black children, but Black parents. And they generally don't make an association between race, poverty, class, socioeconomic status, to the extent that when one tries to advocate on behalf of parents, particularly of Black children, what you're told is, well, we cannot make exceptions. In other words, we run a one-size-fits-all regime, and it doesn't matter what circumstances, mitigating circumstances there might be, we can't deviate from that. Now, that's been made worse, as we all know, by the government's insistence that schools should operate zero tolerance policies. So you have a ridiculous situation where a young person could see her or his friend killed. I mean, literally witness it, be very traumatized, go to school the next day, can't settle down, can't concentrate on learning, and they themselves are targeted as being disruptive or whatever else it may be. And when you try to explain those circumstances, schools generally do not want to know. In other words, there is no sense of empathy or compassion, and certainly no love of children. I mean, if you want to find a regime that actually despises children, look at schools. So we have all sorts of structural inequalities in the system. And the most ironic thing is, if parents don't send their children to school, they can be prosecuted. Some people get sent to prison for repeatedly not making sure their children go to school. But once they're in there, schools could get rid of them hand over fist without anybody taking any action against it. So in many respects, we've got a number of things to contend with. We've got the profiling of Black children, and we saw in relation to London and the gangs matrix, for example, that went totally wild, with the police being able to tell particular head teachers that certain children were on their matrix when those children had no association whatsoever with so-called gang members and were not, by their own behavior, eligible to be put on the gang matrix. So quite a number of the exclusions that we within CEN have dealt with have been as a result of that illegality, that injustice. The second point is that to a large extent, children themselves are not allowed to use their voice. And as I'm sure everybody here can attest to, when children attempt, particularly Black kids, Black boys, who are being accused of whatever infraction, when they attempt to say, this is not what happened, this is what happened to me, this was my reaction to it, they then get told to shut up or keep quiet or whatever it is. And if they insist, then that becomes an infraction in itself. So the voice of children is suppressed. And if their parents attempt to advocate on their behalf, and that happens too regularly in the school's view, in one particular case recently, we've had a school getting its lawyers to write to the parents to tell them to desist from complaining because they're affecting the mental health or whatever it is of their staff. Now, I mean, nothing could be more ridiculous than that. In other words, Stafford Scott at the Tottenham campaign group wrote a monograph some little while ago where he talked about the war on drugs being a war on Black youth. And he's absolutely right. It's not just a war on drugs. There is generally within schooling a war on Black youth. And I am one of those who campaigned in the 1980s and 1990s against the practice of police being put in schools on the grounds that those very children who are being stopped and searched incessantly on the street had to contend with police in schools. And whereas deputy head teachers or senior managers with a pastoral responsibility, no teaching responsibility, pastoral responsibility, would pick up on those kinds of issues routinely in the schooling day, they are now almost non-existent, and the police are being deployed to deal with incidents in corridors or classrooms or whatever else it may be, without the consent of parents. No parent sent their child to school to be policed by whatever it is. So there are a whole range of factors that make Black children particularly vulnerable to these processes. And you mentioned the illegalities that are built into the system. So in many respects, we are at the front end of all of that. Parents come to us, they are distressed, they are bewildered, they do not know the law, they don't even know what the school exclusions guidance is. And they turn up at school, sometimes with an SEN advocate or somebody representing them. Quite often we have to have a battle with the school to allow us to go in to represent the parents. I have been turned away, well, I not turned away, I wouldn't go away. You know, it's a question of saying to the school, if I don't come in there, there's going to be no meeting. And you take the parents and you walk out and you leave them to their nonsense. So the one other thing I would say is this: we've been aware of those things for a very long time. We started the Black Parents Movement in the 1970s because of the way police were treating our Black children in school playgrounds and outside of school and so on. And the one thing that I would say is this: we called this organization the Communities Empowerment Network because we wanted to empower parents with knowledge, information, and skills to hold schools to account. And we saw that as the only way of changing this slide into the sort of situation we have now, where children's rights are being routinely denied. Unfortunately, the empowerment bit of our mission has not been realized because too many people have found it easier to buy this whole neoliberalism business and deal with individualism, what I call private solutions to public ills. So you buy a house in one area that Ofsted tells you is good for getting into a good school. You get your children in there, and we've had head teachers say to us as CEN, what are you complaining about? Yes, these children are Black who are being excluded, but we have another 87% of Black kids in the school, and their parents are telling us, we do not want our children's education to be disrupted by that lot. So if you want to have a fight with us about our school exclusions record, go and talk to those same Black parents who do not want their children's education to be disrupted. Now, at another level, we're dealing with the law and all of that stuff. But at a campaigning political level, what we at CEN want to see is parents in every particular, every school, primary and secondary, collectivizing themselves, arming themselves with information and knowledge in order to be able to hold schools to account, and collectively working politically to put an end to this business, while you as lawyers assist us to use the law to make sure that the rights are not being denied.
Thank you very much. Florence, I was wondering now if you might give us an insight into some of the sorts of cases that have come across your desk at Just for Kids Law.
Oh, I could be here all night because there's such an array of them. And thank you, Gus and Michael, for giving us a bit of history, because that's where I wanted to start as well, but no need to now in terms of discrimination and a lot of Black children being considered educationally subnormal, you know, from the 60s and 70s, and not much has changed. I've had cases of 5-year-olds who have been permanently excluded and with special education needs. Police have actually turned up. There was one particular school where I represented a 5-year-old. They had locked him in a room because they said that he was, they'd never seen anything like it. His behaviour, there were 6 adults in the room with him, and the head teacher decided to call the police on a 5-year-old because he was quite sturdy and big and aggressive for a 5-year-old. And with a lot of the cases that we get, and a lot of the times when I've been to schools, a lot of the teachers, the terminology they use, particularly against Black boys, is that they're aggressive and they're big. You know, it's very systemic in that respect. With the particular case of the 5-year-old, the hearing went on for about 3 hours or so, and it came back that the school said that they were going to change their policies and never to actually exclude a 5-year-old again. So even though it was a very difficult hearing, the head teacher ended up crying and saying that I was picking on her. And I said, if you think that I'm picking on you by just referring you to the policies, how do you think this 5-year-old must have felt when they were having a meltdown? So that's one case that really sticks out, you know, in my mind a lot, and in the early days as well. There's also been some child protection cases where police have also been in presence, and I've asked if they could leave. So we've had cases like that. There's also been the hair case. I wonder if many of you are familiar with Ruby Williams, the hair case. She started out with Just for Kids to begin with, and obviously her identity was being questioned, and that was quite a long journey for her in terms of being sent home because of her afro hair. I've had other cases where you have a white child and a Black child. They've done the exact same there's been this exact same incident, but the black child has received a permanent exclusion, whereas the white child receives a fixed term exclusion. So there are, you know, an array of cases, and I could go on forever, but, you know, we still continue to fight and raise awareness about these types of cases. And, you know, as time has gone on, policies have been changed. Another case that I had where a young black male, he was being quite creative and using tea bags and making out that he was selling weed and selling sweets as well. And when the school realised that he wasn't actually, it wasn't weed, it was sweets and tea leaves that he was trying to sell, they actually permanently excluded him. And this is something that I think everybody should be aware of. It's always a good starting point to always look at the school's behavioural policies to see exactly what they say. Because with that particular case, when I did look at the behavioural policy, the sanction for selling sweets was actually a detention, but they had permanently excluded him. So had to fight for that and managed to get him back in. But by the time I'd got him back in, that he didn't want to return to the school. The other issue is just being a black solicitor. Often when I turn up at these hearings, I've been referred to throughout the hearing as the mum or the auntie, when I've actually explained that, no, I'm here to represent the family. So it's almost as if you're experiencing total shutdown before you've even been able to actually state your submissions and present your case. So yeah, that's kind of it in a nutshell. But I mean, there's plenty others, but they're the main ones that I could call to attention at the moment.
Thank you.
Yeah.
I'm noticing there are a number of questions that are coming up in the chat, which we'll get to. One of the issues which maybe people can think about is whether or not there's a different or how you deal with the different experience of young women and girls through this process. And if people could have a think about that, we'll come back to that later, but I just want to flag that up now. Maxine, I wondered if you could give us some insight. Gus explained how parents can feel very bewildered and overwhelmed, and I know that that's an important part of how you see your role as a volunteer for CEN, and perhaps you could give us an insight in how in the sorts of experiences parents have had going through this process.
Often, well, very often we parents say that they've been listened to for the first time when they've spoken to one of our advocates, which is quite sad, because if there isn't a listening ear in the school and the school is responsible for your child during the day, sad. Anyway, a lot of parents, as I say, they may start off feeling quite vulnerable and weak, but by the time we put them through the process, a lot of them do feel empowered. A lot of obstacles that I have seen parents come up against is when the child has been excluded and they put in a subject to access request, for example, the head teachers will stretch it out to a date that surpasses the IRP date. So they're disadvantaged with the evidence that they can produce just look at the evidence that's available. As Michael said, the training of the governors is another thing of great concern. A lot of parents have told me when I've dealt with a parent, I tend to give them a copy of the exclusion guidance and the Equality Act, and we go through it together. And at the hearing, the governors don't seem to feel ashamed to admit that they haven't even read any of those documents. So how can their decisions be safe? So there's so much that we do, but there's so much that we wouldn't have to do if things were done properly with the children's concerns and futures considered by the schools before they excluded them. I just wanted to say one other thing. A parent that I recently represented said that when schools make the decisions to exclude, they don't think about how it affects the child's home life thereafter, their future, and their educational prospects. Because I've had a recent case where a boy was excluded just before his exams, so he didn't get to complete the exams. All the other children know that he didn't complete it. You know, she said she feels that she's got a stigma that's been placed on her child and his siblings. So yeah, the bigger story has to be acknowledged.
Yeah, thank you. Rose, it may be helpful if you could speak now. One of the questions was to ask if we do understand enough about the experiences of young women in this process, and we're very fortunate that you're here to give us some of an insight into that experience.
I feel like as a young woman, and from my experience in school, was that I personally felt not that I wasn't listened to. Whenever I tried to say something, it was always that it was the teachers or the staff that knew the situation well enough, but I didn't. And I remember that a bunch of situations where, similar to what everybody has spoken about, to do with racial discrimination, in that I had faced a lot of that with my peers in school, and it was actually very bad, and it wasn't looked at as a problem. So even though I had mentioned it, I brought it up. Anytime I brought it up to anybody, it was always a situation of, you know, you're just feeling emotional, you're having a sad day, you're just upset, basically. And I later on realized how bad it was by the time that I had basically left school. And the fact that the teachers didn't think it was a problem, what was going on, and my reaction to it sometimes was, I think, to defend myself. And that often led me to getting excluded instead of them dealing with the problem that was actually very, very obvious, because everybody else could see it, and it was bad. And I think maybe because of how normalized it is for people of like my complexion to be picked on, it just wasn't seen as a problem. I think that's one of the biggest problems, especially in the school that I was in, a very big problem there. And I wanted to bring up another point about mental health issues as well, because that was something that I did experience with having my own mental health issues, and teachers not being able to understand how that might affect you with the way that you might work, even at times when it's just break time, and how you might do things, or what might be comfortable for you that might be different to what the average child does. And that kind of singled me out quite a lot, which I think is really quite toxic, just because that's not going to help you as a young person if you do need support, because I think schools are meant to be there to support you as a young person. They're not there to pick on you. And even though they should help you in things like discipline, things like that, I don't think it should be somewhere you should be scared to go. And that's how it felt for me. I just feel that in general, when it comes to exclusions, so one of the worst things is that what Maxine had explained, the effect that it has on the young person. If you get excluded, you then have a thing against the school. When you come back to the school, if it's temporary, you're not going to come back feeling comfortable, especially because usually it's quite unfair. And the young person knows it's unfair, but again, they're not listened to. And they're not going to then, be very compliant if the teachers are telling you to do something, because everyone's going to assume you did something wrong, even if you know you didn't do anything wrong. So you're more likely then to get excluded because you're not complying now, or because you're more angry, or you're more upset. And then basically everything kind of falls upon you. And I feel that, for me, as a young girl, specifically about that question, is I think they just see you as being more emotional and not really having any real problems. If there were issues that are making you cry or making you sad, it was never something they thought was something bad enough for them to have to give you help for, or to speak to you about, which I think is really not helpful at all. I don't know if that answers the question, but
I think it definitely does, Rose. And I don't know whether, on thinking back to that, what do you think might have made a difference to your experiences at school?
For me, I think it would have been staff being able to understand how to deal with issues that might be a bit more complex than just having an argument with somebody in your class. Because I think even though they have a lot of things to do, there should be more staff available to be able to speak to young people, maybe help them in a situation, especially from me coming from care. There were other issues that I came into school with at that time anyway. And I was never able to have any freedom from that, whether I was home or whether I was at school. And if I tried to speak about it, if anything was going on that I needed somewhere to even have a bit of space, that just wasn't available for me. I think that would really be helpful, even for any child anyway, because you can't always keep up to that routine every single day and not have any space from it, especially if there's something that's really bothering you, that might be affecting you, that could be really bad anxiety, depression, and stuff like that. You can't just try and fit in all the time, because it just won't work, and you will end up kind of exploding really, and then that's what will lead to other bad things like exclusions and so on.
Yeah, sure, thanks. And obviously you've got involved as a campaigner for Just for Kids. Why have you done that?
For quite a number of reasons, actually. Not just for school exclusion, but school exclusions in themselves are really important to me, just because of the way it had affected me and my education. And I feel that it just really made me quite nervous of actually being in any institution for education, whether it's school, university, colleges. I've become quite uncomfortable with them because of that experience. And it's kind of made me feel a bit like I don't fit in because of how I look at it. Oftentimes people see it as something good. I don't look at it that way because of what I've experienced. And I think that there should be somewhere that I'm able to move on from it, because I don't believe I should have to see them that way. And I think everybody just should have access to something that's able to support them. And I mainly want to be part of campaigns like the one I'm in now, and parts of things like this, being able to speak to people and make change because of a lot of the issues there are surrounding young people in general from all areas, whether it's mental health, care system, like what I've gone through, whether it's housing, all kinds of things. I feel like they're quite neglected just because they are young people, that they're not exactly, I think, citizens yet. Like they're forming, but not. I don't see it that way. I think there needs to be more for young people, especially like Florence was speaking about the 5-year-old. They don't see the 5-year-old as really a person of themselves. That they still can have the right to speak, and they still have the right to say what's going on with how they feel, what's going on in their life, what they think is wrong. They shouldn't just have everything done around them. And I think that's the reason why I feel like they need their rights to be heard, and people need to be able to listen to them as well.
Thank you very much, Rose. Jonathan, I don't know if you would also like to contribute your experience as well.
Yeah, definitely. Thanks for all the speakers that have spoken already. When I tell people, that I got excluded in school, most of them can't believe it. I'm an aspiring barrister, but I was naturally well-spoken or outspoken, and I was always ready to challenge decisions. And, throughout school, I did suffer from a lot of discrimination. And this happened probably around year 7, year 8. Just, stereotypes, aggressive, loud. And, when you get excluded, these stereotypes become justified. So it stops, teachers from seeing you anything different from the behavior report or the record that they can bring up in the system. So when I started getting excluded from year 8, year 9, and had no intervention, it kind of went down the spiral. And all I needed was help. All I needed was a bit of intervention, As a young Black male, like some of the speakers already spoken, we do get stereotypes even from outside school. And then teachers, they're not aware of the backgrounds of kids within the community. They might be reading, stuff on the news. I don't know. They might not be. I say it's ignorance. The ignorance of the children's backgrounds. They're also ignorant of some challenges that children might be facing. Hence, why they fail to acknowledge learning disabilities and SEND because of ignorance. And I'm not asking for a teacher to be a counselor. I'm just asking for them to recognize it and then pointing them maybe to someone that can offer help. And so, growing up in school, me and my peers, when we were going through this process, a lot of us, obviously I ended up getting a lot of fixed term exclusions. And even even just talking about the process, I can even talk about experiences I've been through. I never knew about my rights, and neither did my mum. So a lot of these times where I was getting excluded, I would have to kind of represent myself or give my kind of account of what happened, saying this is not fair, telling them why it's not fair. But because I didn't know that I could even have a SEND expert there or could have representation there, and obviously my mum is getting these letters, I'm not sure she understood. So it was just like free flowing, and that's how the decisions were easy, because me and my peers, we didn't understand. So they could easily exclude, permanently exclude. And this was a period of time where the school sought to exclude people just to protect the school's reputation rather to advance kids' careers and their future. You have to remember, you're dealing with vulnerable children who have a great future. Look what I'm doing now. But some of my peers are not here now because of the fact that they couldn't get back into school, and that led to, exploitation outside and unemployment. And that's why I'm part of this campaign, just to make sure that kids who have adversity don't get excluded, but just get help. And I managed to get help at university, but I had to go through means of, private tutoring and private education. So I couldn't get support within mainstream education to get to university. And for example, I'll just quickly share a quick story. It happened actually at sixth form. So I had a lot of fixed term exclusions throughout secondary school. When it came to sixth form, year 12, I decided to go to a school outside my brother, which was kind of a bad decision because there wasn't many young black males going to that sixth form. But as a young kid, I had big dreams for myself. So as I've gone to this sixth form, within 3 weeks, just as I said in secondary school, when these stereotypes came, within 3 weeks within that school, these stereotypes came because the teachers there were even more ignorant. So aggressive, loud, it came quick and it came fast. So when we had they decided to exclude me for 81 days, how they came to that amount of days was very strategic, knowing that after 81 days, there'll be no chance for me catching up in A-levels. There would be no chance. So it was a very strategic decision. And looking back now, I can reflect and see why they sought to do that. So we had a meeting with the governors, and I explained to the governors at the time, I didn't understand what was going on. I didn't know how they reached the decision. But as some of the speakers already said, the governors have relationships with the head teachers. They have a relationship with the staff. So for me, obviously not understanding that I can get legal representation and everything just on my account, it's easy to kind of dismiss it. So after that meeting, the governor said, okay, what we're going to do is, there's clearly not enough evidence here. We're going to go contact the teachers and gain more evidence to kick me out, basically, or to get me excluded, not to gain more evidence to see what the issue is, but to gain more evidence to go to that decision. So when that decision came, they excluded me for 81 days. After 81 days, I tried to come back on the premises. They got police to escort me off the premises. At that time, I needed representation, but I didn't understand or know my rights. And it's just because of my mum and the fact that she just wanted me to go far. She said, okay, Jonathan, let's just do AS. Let's just do it by ourselves. Let's get through it. And I managed to get into year 13 and go to university. But at that point, a lot of kids would give up because you've tried, you've pursued education. It's a right for a child to get educated. You've pursued growth, you've pursued something that you want to do in your life. It's just that the system is actually trying to work against you. And when young kids get this idea that everything's against them, it breeds anger, it breeds not being able to control your emotions. And that's where pastoral leadership comes in, the intervention, just to help kids understand and just how to react. I just needed to know how to react. So yeah, this is the kind of the experiences I went through. Teachers not understanding my background and just being dealt with a lot of stereotypes. And the one thing that kind of sticks out, they would say persistent disruptive behavior. I never understood what that means. They love that word, persistent disruptive behavior. But if you look at the statutory guidelines, it says that if you noticed it, you got to intervene. There might be a deeper meaning behind it. But because of the stereotypes that were entrenched upon me, they couldn't see that I actually needed intervention. And yeah, so that's how it got to the stage where I got excluded. And like I said, people now, they don't understand, like, Jonathan, how did you get excluded? But it happened at that time. So definitely that's why me and Rose are here today to tell you guys about our experiences. And just, yeah, that's it really, truly.
Thank you very much, Jonathan. I think similarly, Stefan can also talk about his experiences.
My name's Stefan. Hello, I'm a part of the panel today. And my experience is just, it goes deeper than a black or a white thing. It is very much deeper than that. It's about ignorant people that just don't want to teach people. I feel like people get into the job just for the money. That's what it shouldn't be. It should be to teach the children, no matter if the child's disrupted. Like in school where I learned differently to everyone else because I got autism, ADHD, and anxiety and PTSD. So the way my mind works is so differently to anyone else. But because I learned in a different way to them, it's seen as disrupted. I can't sit down in a class for too long because my legs start, what's the word? My legs start to shake and I start to get agitated. So I need to walk. And I will tell the teacher that and I'll explain the reason. And they'll be like, oh, you just want to get out of class. That's all you want to do. So, and for me in school, in year 7, I spent a week in year 7, got excluded from year 7, never went back to school. And that was because a teacher slapped me in my face. Then I picked up a metal pole and chased him. And because I chased him, it was wrong. They said, oh, you should have dealt with it in a different situation. But how could you deal with something in a different situation if someone lays their hands on you? So I just feel like, in general, it's just like an apple. When one rotten apple is spoiled, you got to throw the rest away. I feel like they need to start again with the whole thing. Introduce more things that kids would want to learn and stay in school. Because if you notice now, social media, different things, people are grooming people in different ways and people don't see it. It's online now. So when you're kicking a child out of school, where else he's gonna go? At the young age, I felt like I had to have money. And my age, when you're 11, 12, you don't need money. What do you need money for? But that was just the perception I learned because I wasn't in school. I was outside doing what I wasn't supposed to. I was getting groomed by a lot of older people and they was telling me things because I wasn't smart enough at that age and my mind wasn't fully developed. It allowed people to get into my head and sway me certain ways. So when school wouldn't accept me, they would. That's what it is. If school don't accept a child, to a groomer, they always accept you. And that's this basically what I got to say.
Thank you very much, Stefan, and thank you both to Jonathan and Rose as well for sharing what everybody is recognizing to be eloquent and insightful description of the issues that we're seeking to challenge. And it might help, it might just naturally follow on, Ruba, for you to talk about your research that you've been doing, in particular with the connection to what's been called the pipeline to prison.
Thank you. Yeah, let me just share my screen because I want to show a bit more about the disproportionality and the systematic discrimination.
That's fine. That's working.
Great. So at the Harrow Law Center, I mostly work on education law, which involves school exclusions, special educational needs. During COVID, there was securing laptops for people who didn't have them when they were learning remotely. But one thing that we've done recently is a report about college exclusions and young people in the criminal justice system. And we've also done a roundtable event where we invited colleges and various organizations that work with young people. And what's interesting about colleges is you've heard a lot about the statutory framework and the process of school exclusion and the process of challenging it. And that applies to maintain schools and academies. But colleges, for the most part, fall outside of this. And so if you can imagine that, the situation is even worse, and there is even less of an avenue for people to challenge it. So just going back to the disproportionality. So you've heard from Stephanie, but I want to show you these figures so you're really aware. So they're maybe a year old, so there are probably more updated figures, but there's about 10% of the entire school population that is excluded in a year. Boys are 3 times more likely to be excluded. Exclusions peak at age 14, which, you know, sounds familiar from Jonathan's story. Free school meal eligible pupils are 4.5 times more likely to be excluded. Students with special educational needs are more likely to be excluded. And of course, Gypsy and Roma students they have the highest exclusion levels. And in terms of ethnicity, Black Caribbean students are 4 times more likely than their white peers to be excluded. Black African are only slightly more likely. Any other Black background, at least twice as likely as white. White and Black African twice as likely, and white and Black Caribbean 4 times more likely to be excluded. And I think it's important because often labels are placed in a blanket way, but there are differences between different groups, and that's important to recognize the systematic issues that cause that. So there was a report recently written by the Institute of Race Relations, which was published in September 2020, and I think it's a really good read. And it talks about exactly this exclusion to prison pipeline and the criminalization of people of color. I don't like the term BAME, but for lack of a better term, they're more likely to be excluded. And what this report found is that there is a 2-tiered education system being created. And in a way, there is an educational enclosure of people who end up going to PRUs, which is a pupil referral unit, or alternative provision. And in that way, they're more monitored and prevented from becoming radical or socially conscious. And this also has the outcome of criminalizing people of color, because as you just heard from Stefan, when young people aren't accepted in the mainstream education system, there will be other places that do accept them, and that can lead to exploitation and criminalization. So, you know, the staggering statistic, young people who are aged 12 to 18 who are detained or imprisoned, okay, 89% of them have been excluded from school. That is just outrageous. That's a really clear link between school exclusion and criminalization, and completely unacceptable. So going to college and sixth form exclusion. So this area is actually defined generally by a lack of guidance and harmonization. So in a way, we have 2 separate systems for maintained schools and academies, and schools that are independent, or colleges that are just outside this whole regime. And in terms of young people who've been involved in the criminal justice system, who have convictions or cautions, it's often the case that unlawful DBS, which are criminal background checks, are used to stop them from being admitted to college or to exclude them. There are different levels of a criminal background check, and you're not allowed to have one that is more thorough or more enhanced than is necessary. So there are specific professions where it would be necessary to have a more enhanced background check. But it's often not the case. Now, obviously, for anyone who knows anything about the criminal justice system for young people, the purpose of it is to rehabilitate young people and to protect their welfare. Well, these are the stated purposes, at least, and to stop them from reoffending. But when young people lose their place in education, the outcome of that is double jeopardy, being punished twice for the same offense. Obviously, young people in this situation face an imbalance of power, And they are, just as we've heard from everyone, at risk of losing their right to education. So the problems with the system, there's a lack of clarity, different procedures for every institution, and it's unfair to young people. I'm going to stop sharing my screen and I'll tell you a bit more about it if you just bear with me one moment. Okay, so in a maintained school or an academy, for admissions, there's a fair admissions protocol, but colleges and independent schools don't have this. So if a young person is if they unfairly lose their place in college because of a conviction or a caution, there's very little that the young person can do to challenge it. So that institution, that college, may belong to the Office of the Independent Adjudicator, which is a regulator for higher education, but they may not belong to it. If they do belong to it, the young person can challenge an admissions decision with this office, but otherwise it could be subject to the Equality Act. So then you would have to prove discrimination, unlawful discrimination on the basis of a protected characteristic. In terms of exclusions, you just heard about the system with a government body that will meet, and then following that, an independent review panel. And obviously that system is very flawed and unfair. But imagine if there isn't that at all. So the statutory guidance doesn't apply to independent schools, city colleges, colleges for the technology of the arts, some sixth forms, various things. And the problem is that it's now mandatory for young people to continue to be in education after the age of 16 until the age of 18, or do certain amounts of voluntary work or traineeships or apprentices. But essentially, young people need to be in education, but this aspect of it is not protected or regulated in the same way as maintained schools and academies are. So this is the situation. And you also can't lodge a judicial review because obviously these bodies, these independent schools and colleges, they're not really seen as public bodies. So how can you challenge an exclusion at a college? Well, each college will have their own internal procedure. And that's it, really. You just have to follow the internal procedure and follow that appeal avenue. But it's often not very helpful. If they're members of the Office of the Independent Adjudicator, you can go that route. And that office is a public body, so you can challenge their decisions at judicial review. But again, not the college to begin with. Okay, so in terms of criminal convictions, a lot of young people don't really know what their rights are. There's no general obligation to disclose that. You only need to disclose it if you're asked. And for most courses, there is no obligation to ask about criminal records. And obviously colleges are subject to the Rehabilitation of Offenders Act. And then there are the different levels which they can ask for. So for professions where people will be working with children or vulnerable adults or healthcare or medical work or anything to do with law enforcement, in that case, if you are in a course that pertains to those subjects, then you can be asked to consent to an enhanced DBS check. But even for these roles, there are some things that don't need to be disclosed. And then even for these roles, there are ways around it. So we've worked with fantastic charities that support young people, and where the young person had an offense that meant that they weren't allowed to work with children or young people. So there were ways to safeguard so that they wouldn't come into contact with children or young people, and they were still able to complete their course. And all that's needed is a bit of flexibility and working with the youth justice system. And, you know, in a positive move, Ucas, which is the online system for a lot of universities and colleges, they announced in May 2018 that they would no longer require all applicants to declare unspent criminal convictions, and they would only be asked to declare them where it directly relates to the course. So the problem here is, though, there isn't really anything to do, there isn't much to do to challenge a college where they've asked for a criminal background check where it isn't necessary, or they've asked for a more enhanced one where it isn't necessary. Because while it is an offense and it is a breach of the Police Act and the Rehabilitation of Offenders Act, there has been no single prosecution of that to date. And it's really difficult to prove that someone has knowingly asked for an unnecessary criminal background check. The only thing that a young person could do is first consent to the check, but then challenge it after it has already started. And also the young people are put in a position where they don't want to say anything because they don't want to risk losing their place in education. So, bearing in mind the disproportionality in the justice system and in school exclusions, you can see how problematic and how systematically discriminatory this whole system is. And beyond all the flaws that you have in the normal school exclusions process, this is a whole area that is just completely offers no avenue to challenge it. So if you're a young person who's excluded from college, you're just in an incredibly difficult situation. I had one such young person where we were able to challenge it and we were able to have him reinstated, but I think it was rare because it was just a really blatant case of injustice and they realized that. But this is something that really needs to be addressed at the policy level. And in terms of young people with criminal convictions, what I will say is that when young people are released, they're involved, they have youth offending team officers who work with them and they're supervised, and there are all sorts of conditions that are set for them to meet. So if the school is worried about safeguarding, then there's a whole system in place to monitor that. And also the youth justice system, which is meant to be fully competent to deal with risks, is there to work with them. So there should be more cooperation between colleges and education and the youth justice system. And I'll leave it there. Thank you.
Thank you very much, Ruba. Obviously, our discussion has ranged far and wide, and what we want to move on to now is to look at what currently is in place in terms of the possibilities for access to justice and to legal representation. Ruba's explained where one of the gaps is, particularly for young people who are at the age of going to college. And Phil, I wondered if you could just give us some of an insight into your experience of working within the current funding arrangements for legal aid in exclusion and education-related cases.
Yes, I can be quite brief in relation to legal aid for education cases, and I can be even briefer in relation to legal aid for exclusion cases, because it doesn't exist. The only legal aid that's available is the basic form of legal help, which enables people to advise in the office, draft documentation, and to correspond, but doesn't cover representation before tribunals or before courts. The exception to that is when there's discrimination or when there's special educational needs, but it's still the most basic form of legal help. So there's massive gaps in representation because it's one of the most complex areas of law in terms of special educational needs and exclusions, or discrimination and exclusions. And to send someone along with some submissions which you've drafted carefully after 20 years of experience, it's very hard for them to answer questions on those submissions. So it makes it more important that the project, pro bono, law centres, voluntary organisations are involved and are able to assist parents when there's such a gap in legal aid. So the only other point I wanted to make is that when I think about exclusions, I also think about managed moves and the unregulated area where you terminate a managed move either because someone has been on a managed move for a very long period of time and has never given the protection of going on roll, or you just terminate it without a fair process because there's no statutory regime dealing with terminations of managed moves. So that was the only other point I wanted to make, other than the fact that Jonathan has brought back some awful nightmares of 30 and 40 days exclusions, and going back to those times when they say it should be very short as a punishment, and people just found themselves out for months and months and months waiting for police investigation. So I've had a few stories tonight which have brought back some awful memories.
Thank you for that. Thank you for that, Phil. And it was one of the issues that was raised in the chat about what was described as grey or unofficial exclusions. And so from your experience, is that a significant problem?
Yes, I mean, getting people to withdraw, getting people to agree to a managed move has always been a problem, saying it will be on your record. But even when you've got a more formal managed move, schools just can terminate them for non-disciplinary reasons. They think they can just say, well, people don't like you here, or you get attacked and you're the victim of an assault, and they're saying, well, it's no good you remaining in this school, your managed move's terminated. And there's no sort of meeting, no representation, no documentation. And the only other thing which Jonathan mentioned, which again brings back bad memories, is the new electronic systems are very good because you can record incidents, but you can soon find you've got a file with persistent disruptive behavior on it if you record every little incident, and it makes it very hard to challenge, because when you're not challenging a one-off serious event and you're going through a log with 30 incidents, you do tend to get the panel saying there's no smoke without fire and there's a detailed log. So the computers haven't necessarily helped in being able to challenge some of those areas.
Can I just pick up on that, actually, because that touched a nerve on some of the cases that I've been involved in. I could also see Jonathan nodding along as well. The way that data is collected is really problematic for the reasons that Phil was alluding to, but it's also worth bearing in mind all of that data gets inputted by the school, and most of that data, the pupil won't have any control or opportunity to say anything about the way that data is recorded, and it will sit there until you get to a hearing, and suddenly you will have schools pulling up all of these sorts of incidents that might have been 2-3 years ago, and at the time where everybody was kind of satisfied that it wasn't a major significant event, all of a sudden, because they're looking for justification for a decision, they'll start pulling up all of this stuff. And I think it really speaks to the imbalance that is at the heart of the system. And I think it might have been Maxine who was talking about when you ask for a data subject access request and then they take months and months to respond to it, knowing that you want it for an independent review panel appeal, and they'll throw all sorts of supposed statutory exemptions to justify delaying it. It really is problematic. And the other thing I wanted to say, almost everything that Jonathan, Rose and Stefan were talking about in terms of their own personal circumstances and the ways in which they would have liked their schools to consider them are things that the law, so far as it applies to schools in terms of the statutory guidance, are supposed to think about. It's there in black and white. It should be theoretically possible for a governing body to review a decision of a head teacher to exclude without having to hear representations from anybody. Because if they were looking at things independently, which of course in practice they're not, it's all written there for them, more or less. And I think that's really a point that we have to grapple with, which is that the problem is not so much, I mean, there are problems in the system that exists, right? But fundamentally, there's an enforcement problem. And there's a legal black hole in exclusions for a reason. And that's because they don't want lawyers involved in challenging these decisions, even though at the same time, they're asking governors and teachers and so on to apply potentially complex areas of law. You know, and you get the most ridiculous arguments about why none of this is relevant, when in fact the whole system is meant to operate on the basis that you look at the child who is being excluded just as much as you look at their potential victim. The fact is that the system is not set up to properly protect the rights of students or pupils, and the political impetus at the moment is to encourage what is effectively a form of lawlessness in our schools.
Thank you, Michael. I was wondering if we could move on to think a little bit about the policy angle and the campaigning. In the chat, a number of people have made reference to the fact that there is a Dfe consultation that is out at the moment, and I think that it's going to conclude, I think, in the autumn. Perhaps someone can correct me about that. But Michaela, I don't know if it would be if that's something that you could talk about as part of, I know, the really effective campaigning that Just for Kids does.
Yeah, absolutely. At Just for Kids Law, we recognise that young people are experts by experience, and I'm sure that I don't have to emphasise the point of how inspiring our young campaigners are. Jonathan, Rose and Stefan, I think if we are looking to solutions to these problems, we really need to look no further than those who have been most impacted by it. So Jonathan, Rose and Stefan, along with their peers, lead a steering group in our campaign on school exclusions. And we're very fortunate at Just for Kids Law. We have a policy team that also work on school exclusions. So we have direct influence into policy and hopefully into practice as well. So we do have influence in the likes of consultation that's up and coming in the Department for Education and the APPG inquiry as well. But something I think that struck me through this conversation is the real importance of creating these platforms for young people's experiences and voices to be heard. And I know we speak a lot in our steering group about the motivation for a lot of our young activists is that they have come to a point where they're able to use their experience for change, but they're not only doing it for themselves, they're doing it for the thousands of their peers and other young people who aren't in the position to be able to speak on platforms such as this because they've been pushed further to the margins of society through their exclusion. And so it's just really emphasised the importance of platforms such as this, of the School Inclusion Project, which we really look forward to working with, and our campaign group as well, because the huge potential in the young people who are excluded from school cannot be overlooked, and the fact that so many young people, whenever they're excluded from school, go on down the routes that have already been mentioned today, is just a complete systematic failing and a real shame on society. So I'm very proud to work alongside the young people who have spoken tonight and raise not only their voices, but like I said, also their peers who aren't involved in the campaign, and create the change that's very much needed.
Yeah, well, I know we know that there has been established an all-parliamentary group on education, and it seems to me that one of the things that we should be lobbying them for is to have a session where young people like Jonathan, Rose and Stefan, who've spoken, actually speak directly to those who have the power to make change. And that might be something that we put at the top of our agenda for at least for policy and campaigning work going forward. Looking at the time, I think that we ought to now just move on to give you some more of an outline of what the Schools Inclusion Project aims to do, and critically how you might get involved in it. And for that role, I'm going to ask Ollie to speak.
Thanks, Stephanie. I have set a timer so that I don't go over 5 minutes. So I'm briefly going to talk about the aims of SIP, who should join, and how it will work. So the aims are, we want to facilitate representation. We want to get more lawyers and skilled up advocates representing children and young people in these exclusion hearings. Through having people on the ground, we're going to make the arguments about the Equality Act. We're going to make sure that schools are held to account. And we're going to ensure that procedural safeguards are actually upheld. Well, that's the aim, at least. We want to share knowledge and best practice and upskill people. And finally, we want to identify and address systemic problems. Through this forum for collaboration, we want to, if someone's got an issue in one place and someone else mentions it, and someone else mentions it, it starts to look like a systemic problem. And it's a way of gathering an evidence base through our SIP members of exactly what's happening on the ground, which particular local authority is doing X, what new DfE policy is doing, what impact that has. So through we want to create a forum for collaboration, bringing together advisors, NGOs, campaign groups, parent groups, and lawyers, so that we can share expertise, share insights, and work together to address these problems and fulfill the aims I just mentioned. So who should join? Well, the groups I just mentioned, but I think I particularly want to emphasize that if you're a lawyer and don't think you're not an education lawyer and therefore shouldn't join, wrong. We can train you up. Public law if you've got an understanding of public law principles, we can get you up to speed on exclusion issues. But we want to look at not just exclusion, but this is the school inclusion project. So looking at issues such as off-rolling, which is related, but like racially discriminatory uniform policies, the use of isolation booths. We want to make schools a discrimination-free zone. That is an ambitious aim, but it goes beyond just making sure exclusions are there. It's making sure that the whole process and the experience of being at school is as empowering as possible. So if you're hearing anything from this, join SIP and get involved, because that's the only way that it will work. As to the nuts and bolts, how will it actually work? Well, it's set out on our website, and I don't want to go into too much detail after hearing such empowering talks. Ending on details of how to join a Google group is a little bit of an anticlimactic end. But the details on our website, it's based on the Housing and Immigration Group, for anyone that's familiar with HIG. And the idea is that people join this Google group, and if they have a case that they want to refer, they'll send it around and hopefully someone will pick it up. If they've seen a new policy come out at a particular local authority, share it and we can discuss it. There will all, in addition to having this email forum, we plan to have quarterly meetings so we can catch up and address these policy issues in more depth and take a strategic approach going forward. Finally, and an overarching aim of SIP is to ensure sustainability of this. It's all well and good us encouraging people to do it pro bono, but that's not good enough. And it shouldn't have to be down to grant funding. It shouldn't have to be down to people doing it out of the good of their hearts. We need legal aid. And we've had success in the Special Educational Needs and Disability Tribunal. I've seen a few solicitors that I work with in relation to SEND work who've successfully secured exceptional case funding for representation in those appeals. We want to try and get exceptional case funding in exclusions process. If the legal aid agency knocks us back, we will challenge them and we will establish that Article 6 is engaged. We'll overturn Tom Hood, this awful case from over a decade ago, and we will make sure that we will push the legal aid agency to grant where there'll be a risk of Article 6 breach. And by all of us working together and all of us making these applications for legal aid, we'll build an evidence base to argue that it should be brought back into scope. So we have ambitious aims. We've got a website. I'm going to put the link to the website in the chat so you can read a bit more about it. But hopefully hearing from all the inspiring speakers today has fired you up and make you see that getting involved with SIP could make a real difference and address systemic discrimination in an important way. Thank you.
Thank you, Ollie. I think that on that note, we have overrun time. I haven't got anything that I can better what Ollie says. It is the touch word, I think, is empowerment. And obviously that's something that the CEN has been seeking to achieve for a very long period of time, and we hope we can take that project further now. And ultimately, you can see what you can do if young people are empowered. We've heard that in a eloquent and moving way from Jonathan, Rose, and Stefan. That is at the heart of what the project seeks to do, and we really hope that you will join with us in making the aims of the project a success, so that we can bring some improvement in access to justice. We can engage at a policy level in seeking to reduce exclusion and move the agenda to an education system that is inclusive and empowering for all of those who are taking part in it. We will be in touch, and we hope that you will continue your interest and active involvement in this important project. Thank you very much.